Friends, my name is Anvesh Madhukar. I am on the panel of Delhi High Court Legal Services Committee. Today I am going to talk about the Medical Termination of Pregnancy Act, the history, how it has evolved, and as being a part of the Legal Aid Delhi High Court Legal Services Committee, how we have come across such cases and what we could do to assist the poor litigant. So the MTP Act was enacted in the year 1971, but before that, the in the 1960s, when the government set up the Shanti Lal Shah Committee, basically to evaluate the need of abortion law, because earlier it was a crime under 312 of the Indian Penal Code. Causing miscarriage would attract a punishment up to 3 years. Subsequently, the provision is still there. Up to 3 to 7 years is the imprisonment for termination of pregnancy if it is not in accordance with the MTP Act. So there was a need to have a law in place so far as abortions were concerned, and that's how the MTP Act came into being, which has lastly been amended in the year 2021. The earlier act provided for medical termination of pregnancy on several grounds, one of which broadly it was divided into three major compartments. One was the health measure for the mother of the child. Second was humanitarian grounds, such as where the pregnancy arose out of a sexual crime, and if the mother was a rape victim, that was the second category. And the third category was if the fetus was not normal, or there was a possibility of the child not leading a normal life and being abnormal in any way, handicap or otherwise. So these were the three broad parameters under which the MTP Act would work. Now, over the years, things have changed, the medical facilities have changed. Earlier, there was a time frame. One could abort a child under the MTP Act up to 12 weeks by one practitioner alone, if he was of the opinion that it could cause injury, mental injury or otherwise, to the mother of the child. Now that has been amended and been increased to 20 weeks in a normal case, and if it is beyond 20 weeks, the opinion of two medical practitioners was required in the earlier act, and now that has been changed, and the time frame has now been changed to 24 weeks. So earlier it was 12 weeks and 20 weeks. Now it is 20 weeks and 24 weeks. Beyond 24 weeks, one would need a permission from the courts to go ahead and terminate the pregnancy. So a lot of times we come across cases where a rape victim sometimes does not even know that she is conceived, and being a child and considering our social economic situation and so the society, some of these victims are not even aware that they're carrying a child, and of course they are minor children. And once it is found out that yes, the child is pregnant, then there is the entire requirement. Most of the time, by the time they find out, is more than 21 weeks, sometimes even 24 weeks. Post 24 weeks, they find out that the victim is pregnant. In that situation, one moves the court, then a medical board is constituted, and opinion is sought from the doctors as to whether it can be done or not. And of course, once the doctors have opined that it can be done, then the court passes an order to get the termination of the pregnancy done. So, but however, this takes a lot of time, and under the Act, there is a requirement that every district should have a medical board. Now, in the recent judgment, again assigned to me by Delhi High Court Legal Services Committee, Justice Vankanta Sharma, in the recent judgment has passed certain guidelines, and it should be applicable to all cases in Delhi. One of which was that it was found out that only 4 hospitals has a medical board. Therefore, the Honorable Court issued guidelines and said that all the hospitals on the government panel should have the medical board, and they should do the needful to constitute the same. Apart from that, the court also noted and issued a guideline that the Commissioner of Police will be circulating this to all the investigating officers. Where a child is found to be pregnant, then in that case, the child is to be taken to the medical board on the very same day to get an opinion of the doctors whether it can be done or not, whether it is safe to conduct the medical termination of pregnancy or not, so that by the time one comes to the court, the medical board's opinion is already theirs in order to expedite the process. Since time is of essence in such cases, this is a very welcoming order and guideline from the Honorable Court, because a lot of time we lose out at least 3-4 days till by the time the board is constituted, an opinion is sought, an opinion is brought to the court. It takes a lot of time. So to cut short that process and in order to enable the victim to expedite the process, these guidelines was issued. It was issued in minor R versus state in January 2023. And of course, another decision of the Honorable Supreme Court recently, X versus the NCT of Delhi, there also the Honorable Supreme Court, 3 judges said that there is no discrimination or no distinguishing factor between a married and an unmarried woman. So far as the MTP is concerned, it can be done in a case where the woman is unmarried also. So yes, it does not segregate or discriminate on the social norms and acceptance of the society, where somebody who is unmarried may be looked down upon, even if the person is not a rape victim. That right has also been given by the Honorable Supreme Court. Apart from this, there was an earlier judgment of this Honorable Court of Delhi High Court, again assigned to me by Delhi High Court Legal Services Committee, where Justice Pratibha M. Singh, she also was pained at the way the doctors were giving opinion, and therefore there also guidelines were issued as to how an opinion is to be given. It is just pointing out that in that case, the doctors had given an opinion that it may not be appropriate to terminate the pregnancy. But what was the reason why they had come to this conclusion, all of that was not given in detail. The court was pained to write that the report was sketchy and did not really help and assist the Honorable Court in passing any order. Be that as it may, the court still passed an order. In that case, the lady who wanted her pregnancy to be terminated was 34 weeks, so much beyond the scope of 24 weeks even after the amendment. But the Honorable Court held that it is ultimately the choice of the mother whether to continue with the pregnancy or not, and that right cannot be taken away. It ultimately is mother's choice, which again was a very welcoming decision, because as we know, in the western part of the world, they are still debating over the right of abortion. Recently, the Honorable Supreme Court of the United States of America has struck down Roe versus Wade, where it was earlier said that it is the right of the woman to continue or not to continue with pregnancy. So that being the case, we here are very fortunate to have such laws in place, and we have been able, as a counsel on the panel of Delhi High Court Legal Services Committee, also I say that we have been successful in obtaining these orders, and we have tried that no time is wasted. And looking at the urgency, we've been able to obtain such relief from the Honorable Court.